Good afternoon, everybody, and thank you for joining us for today's presentation, Managing Medical Marijuana, What Connecticut Employers Should Know. My name is Matthew Curtin, and I'm an employment attorney here at Mertha Kalina. My colleague, Sarah Gruber, will be co-presenting with me today. I'm going to take a moment to go over a couple of points. First, all callers are currently in listen-only mode. If you have questions during the presentation, you can write them in the questions box of your webinar toolbar, and we will answer them at the end of the presentation. This webinar is being recorded. All of today's participants will receive an email following today's presentation with the PowerPoint slides, a link to the webinar, and an attendance certificate. So having said all of that, let's go ahead and get started. I will note that we are not providing any legal advice today. This is a general overview of medical marijuana in the Connecticut workplace. So having said all of that, let's move to the first slide. Just to give everybody a general overview of where we are today and how we got there, currently 29 states plus the District of Columbia have enacted legislation permitting the use of medical marijuana. And in some of those jurisdictions, recreational marijuana is also lawful. We're not going to discuss all of these different jurisdictions. Today's presentation is really limited to the scope of discussing Connecticut's medical marijuana laws. However, I thought it would be helpful to give everybody an idea that this is an issue that's not only occurring in Connecticut, but it's happening to the north in Massachusetts, where recreational marijuana is also lawful. Note that recreational marijuana is not currently lawful in Connecticut, but it is in Massachusetts. So this is really a hot topic with a rapidly evolving area of law. There's lots of uncertainty for employers from state to state and on a federal basis. So it's something that employers need to pay attention to as time progresses and really monitor developments as they happen. There's still very little guidance from courts across the country. We're starting to see a handful of decisions come in concerning various states' marijuana laws. We still have a paucity of jurisprudence in Connecticut, but we'll discuss that as we proceed with this presentation. One thing I will note, and I'm sure that most people on this call do know this, but just for clarity, marijuana is still legal under federal law. It is a controlled substance. It's categorized as a Schedule I substance. So one of the issues we'll be discussing today is the interplay between federal and Connecticut state law, given the fact that medical marijuana is lawful in Connecticut, but it is not on the federal level. So because Connecticut allows the use and prescription of medical marijuana, we want to look to the statute that permits that use. That is the Palliative Use of Marijuana Act. And in Connecticut, employers need to be aware of the Palliative Use of Marijuana Act, which I will refer to as PUMA throughout this presentation, because PUMA has an employer anti-discrimination provision that we will describe in detail a little later on. One thing to note, how is an employer defined under PUMA? And it's a very broad definition. For the purposes of PUMA, employer means a person engaged in business who has one or more employees, including the state and any political subdivision of the state. So that's a broad definition, and you'll see that that's even broader than the anti-discrimination provisions under state law and federal law. So practically speaking, PUMA applies to any employer doing business in Connecticut as long as you have one employee, which really means all employers. PUMA exempts qualifying patients, which is a defined term of art we'll get to, primary caregivers of qualifying patients, and prescribing doctors from criminal penalties that would otherwise apply to those using and distributing marijuana. The explicit anti-discrimination provision of under PUMA prohibits discrimination against a qualifying patient and primary caregivers by schools, landlords, and most relevant to our discussion, employers. So on the next slide, you will see the definition of employer under the Connecticut Fair Employment Practices Act, which is the statute in Connecticut that guards against race discrimination, national origin discrimination, sex discrimination, etc. And the reason we're including this definition in here is for exemplary purposes to show that the definition of employer under the CFIPA is even narrower than that of PUMA, because under CFIPA, employer includes the state and all political subdivisions thereof. That means any person or employer with 3 or more persons and such persons employee. And so you see, you could have less than 3 employees in Connecticut and not be subject to the anti-discrimination and harassment provisions of CFIPA, but you could still be subject to the anti-discrimination provision under PUMA. So PUMA really is about as broad as it gets for purposes of defining employer. So on the next slide, we see that this is the actual statutory language making clear the anti-discrimination provision under PUMA. So unless required by federal law or required to obtain federal funding, no employer may refuse to hire a person or may discharge, penalize, or threaten an employee solely on the basis of such person's or employee's status as a qualifying patient or primary caregiver under PUMA. So this is a really broad anti-discrimination provision on its face. And let's start with, before getting to the actual anti-discrimination provisions, you'll notice under the first bullet point, there's a carve-out there, a little exception for PUMA that says, unless required by federal law or required to obtain federal funding. So if you're an employer that has a federal requirement that you cannot employee or that you can discipline an employee because of their use of illegal marijuana, then you're carved out from this anti-discrimination provision. So, for example, DOT regulated employers. However, generally speaking, most employers are going to be subject to this anti-discrimination provision. Now, let's get into the actual definition. So it says no employer, which again is any entity that has 1 or more employees, no employer may refuse to hire. So this means that this applies to job applicants as well, not only employees. And we're seeing a lot of litigation from job applicants who are screened out because of a failed drug test, and even though they are lawful medical marijuana users under Connecticut law. So employers need to be aware that it's not just employees that are protected by PUMA, but it's also job applicants that are qualified patients or primary caregivers under PUMA.
Now, how would I know if someone's a qualifying patient? Let's say we get a drug test and they said, oh, well, I'm a medical marijuana user in Connecticut. How can I verify that?
So generally speaking, what you will see is a qualified patient receives a medical marijuana card from the Department of Consumer Protection in Connecticut. The Department of Consumer Protection is the agency charged with regulating PUMA, and they've issued a variety of regulations that touch upon PUMA and discuss dispensing and cultivating and possession of medical marijuana. So qualified patients will receive a medical marijuana card from the Department of Consumer Protection so that qualified patients can prove to, for example, employers or landlords that they are lawfully using medical marijuana under Connecticut state law. So generally what we're seeing is that applicants for jobs, they're being proactive about it, and they're getting ahead of it, and they're showing their employers, their prospective employers, their medical marijuana card to prove their status as a qualified patient under PUMA. And that will really trigger the protections of the anti-discrimination provision, because at that point, the prospective employer has knowledge that the individual is a qualifying patient under PUMA. So beyond job applicants, again, this applies to employees as well. So you can't refuse to hire somebody, but you can't discharge, penalize, or threaten an employee, an existing employee, solely on the basis of such person's or employee's status as a qualifying patient or as a primary caregiver. So that's important going back to the solely on the basis language. Now, there can be other legitimate reasons to refuse to hire an individual that also is a qualifying patient. They might not be qualified for the job in a variety of ways that has nothing to do with their status as a qualifying patient under PUMA. Still lawfully refuse to hire them as long as it's not solely on the basis of that person's status as a qualified patient. And this is another interesting provision here, it's not just qualifying patients that are protected, but it's also primary caregivers. And if somebody advises you that they are a primary caregiver to an individual who is a qualifying patient, you cannot refuse to hire that person because of their status as a primary caregiver. You cannot discharge, penalize, or threaten a primary giver solely on their status as a primary giver under the anti-discrimination provision of PUMA. Or you might be subject to, you're subjecting the company to exposure for a violation of PUMA, which we'll get to a little bit later. Under the next slide, this is discussing Connecticut drug-free workplace policies. Such policies are still allowed under PUMA. And that's because nothing under PUMA restricts an employer's ability to prohibit the use of intoxicating substances during work hours or to restrict an employer's ability to discipline an employee for being under the influence of intoxicating substances during work hours. Now, this is important because it means that as an employer, you do not need to allow a person to be intoxicated by medical marijuana while on the job. You don't need to allow a person to consume medical marijuana generally speaking, you don't need to allow somebody to consume medical marijuana while on the job. Now, there might be some disability accommodation concerns that we'll touch upon later, but as a general rule, PUMA recognizes that employers still have the ability to prevent employees from using or being under the influence of medical marijuana while on the job.
And this makes sense, right? It seems like we have PUMA saying, okay, we know that there are people legitimately out there that have a medical condition where medical marijuana is required to ameliorate symptoms of that condition. But we also recognize that employers have a legitimate interest in maintaining a safe workplace, maintaining a healthy workplace, and there may be qualifications of the job that would be interfered with if medical marijuana were consumed in the workplace. So that's why we have this provision here that says PUMA protections do not apply to ingestion of marijuana on a school bus, a motor bus, in the workplace. And again, as Matt said, there may be other requirements about consumption in the workplace, but that's not, at least by the letter, in the PUMA statute as it stands. So the next question is, what types of patients does would PUMA apply to? Again, you're dealing with qualified patients that have a card that's been issued by the Department of Consumer Protection. The statute helpfully lists the conditions that would qualify someone to get one of those cards if all other conditions are met. That includes cancer, glaucoma, epilepsy is a common one, PTSD is also a common one, and this isn't an exhaustive list. There's also regulations that add additional debilitating medical conditions that would qualify someone or could qualify someone to receive a medical marijuana card through the DCP. Because it's a regulation, it doesn't require legislative action to add to it, and the list on this slide is just a small section of it. If you're concerned or you're not sure, or you're just curious about what conditions would qualify someone to receive a card, you can just go look it up in the regulation, and we'd encourage that because it could be an evolving list. But that said, if someone has a card, you can presume, at least in part, or you may be entitled to presume, as a matter of law, maybe, that the person validly has a medical marijuana card.
Yeah, that's right. You don't want to put yourself into second guessing the Department of Consumer Protection as to whether somebody has a valid prescription or whether they have a covered condition. If somebody shows you that they have a card from the DCP that establishes their status as a qualifying patient, that's good enough to trigger the protections of PUMA for at least purposes of the employer anti-discrimination provision. So we talked about the Department of Consumer Protection regulating the prescription use and cultivation of medical marijuana. The Department of Consumer Protection maintains a website that contains registration information. One thing that the Department of Consumer Protection has not done and is relevant to this particular presentation is issue regulations concerning the employment aspects of PUMA. Has not weighed in on the employment anti-discrimination provision, which has left a void for us to interpret how those anti-discrimination provisions might play out in a legal setting. Another thing that the Department of Consumer Protection has not done is provide an enforcement mechanism for violations of the employer anti-discrimination provision, which is significant because the PUMA statute itself does not set forth any enforcement mechanism for an employer's violation of the anti-discrimination provision.
And you'll note, if you pull up the statute yourselves, you'll see statute after statute of, okay, who can grow and who can manufacture and who can distribute and how do the cars get there and what do the doctors say and what's the diagnosis. And that's why this is so interesting, is because there's really only that one section that has anything to do with employers. For the most part, it's who can qualify for such a card, how do doctors administer this program. But for the employment lawyers out there and the employees and employers that are subject to it, just really that one part that has to do with PUMA.
That's right. And that's a nice segue into employer legal issues under PUMA. So we talked about earlier that there really isn't a lot of judicial gloss on the PUMA statute. When I say there isn't a lot, there is only one case out there so far, and that case is still winding its way through the court. So it's an active case. It's at the district court level in Connecticut. It does not have binding precedent. It hasn't been fully resolved. The only thing that's happened in that case that's been published is a decision on a motion to dismiss, which really is just a threshold issue and doesn't have much binding precedential value. What it does is provide a little bit of guidance that in no way binds employers, because it's not a appellate court and it's not a Connecticut state court, but it's the only thing we have to go on so far. And that case is Nossinger versus SSC, Niantic Operating Company, doing business as Brydebrook Nursing and Rehabilitation Center. Two significant issues that came out of that motion to dismiss decision. The first one, and I think probably the most relevant for everyone here, when we're talking about enforcement mechanisms and the DCP not weighing in or establishing an enforcement mechanism, that left us to wonder, well, is there anything an employee can do if an employer violates the PUMA? And this particular court, at least on the motion to dismiss level, said yes. Interpreting what a Connecticut state court would say, this district court judge said that there is an implied private right of action against an employer for a violation of the employer anti-discrimination provision of PUMA. And the reasoning to support that proposition is that without a private cause of action, PUMA would have no practical effect because there is no other enforcement mechanism. So even though the legislature was silent as to whether there is an enforcement mechanism and as to whether there are any potential damages for violation of this anti-discrimination provision, even though the Department of Consumer Protection has not weighed in on an enforcement mechanism, this particular court has said that it would be absurd for there to be no enforcement mechanism, and therefore the courts will read into PUMA a implied private right of action. What does that mean as far as potential exposure? We still don't know. This case is actually still pending. There's still arguments being made. It's up on summary judgment motion right now. There's arguments about the scope of potential damages for a violation of PUMA, whether it's just back pay, whether there's front pay available, whether there would be punitive damages available to punish and deter employers for violations of PUMA, whether there would be emotional distress damages available to an employee for a violation of PUMA. These are all issues that are still unsettled. And from a day-to-day HR perspective, it might not have that much practical effect, but for employers that are faced with challenges, lawsuits, it's very important because you can't really assess the scope of your potential damages for a violation of PUMA because there's no guidance from the legislature, there's no guidance from the Department of Consumer Protection, and there's no guidance yet from any court. So those are all still unsettled issues, and hopefully there will be guidance in the near future, but I think it's still going to take a little while before we get anything concrete. So the second issue that was relevant from the Nossinger decision, sorry, we got hung up on the private right of action, but this has less of a practical effect on a day-to-day basis, but it's worth noting the defendants on the motion to dismiss level at least argued that various federal laws preempted the state PUMA law. And basically the argument is the Controlled Substances Act, the Americans with Disabilities Act, and the Food, Drug, and Cosmetic Act all preempt this state law prohibiting employers from discriminating against employees because there's various pronouncements in these various federal laws stating that marijuana is unlawful on the federal level. The judge, at least on the motion to dismiss level, said that as a matter of law, he was rejecting all of these arguments, and he said that there's no federal preemption under any of these laws. Primarily, my reading of it was the reasoning that there's nothing in here in any of these, the CSA, the ADA, or the FDCA, these federal laws, that prohibits an employer from hiring an employee who engages in unlawful drug use during non-working hours. And on the basic facts of this case, those are the allegations of this case. So it might be limited, the precedential value of that no federal preemption decision might be limited to the facts of this case. But again, it's all we have to go on so far. So that particular judge said under the particular facts of that case that there was no federal preemption. So a couple other employer legal issues that we're looking at, and we'll get into a little more in depth on some subsequent slides. Again, the Americans with Disabilities Act and corresponding state laws, we're seeing a lot of disability issues overlap with qualifying patients under PUMA. Because generally speaking, and not in every situation, because you're going to have to evaluate this on a case-by-case basis, but if somebody has a card from the DCP that qualifies them as a qualified patient under PUMA, they're arguably going to have a disability under either the state's CFIPA law or under the federal ADA. And so what happens then, you have to take into consideration whether or not you have to engage in the interactive process or provide an accommodation that could be reasonable to help the person perform the essential functions of the job. Another law that we're seeing overlap with is FMLA and the state FMLA. Another one is OSHA, because under OSHA you have a duty to provide a safe workplace. And just generally there's a tension between the state law decriminalizing the use of medical marijuana and allowing and providing protections for employees who are qualifying patients or primary caregivers. I will note, we talked about this a little bit earlier though, the DOT has taken a position on this because obviously DOT regulated employers have testing concerns because they have testing requirements. The DOT's position is that regulated employers may still screen out medical marijuana users. The DOT issued a drug and alcohol policy compliance notice and has reissued it several times, making clear that DOT drug and alcohol testing programs are not preempted by the state medical marijuana laws. And the specific statement is that it remains unacceptable for any safety-sensitive employee subject to drug testing under the Department of Transportation's drug testing regulations to use marijuana. So there is clarity on that point at least.
So really one of the biggest takeaways about PUMA is you wonder how is it going to affect my relationship with my employee. Well, it didn't really change the legal landscape as it existed prior to PUMA. In other words, there still needs to be the same compliance with other state accommodation laws, other federal accommodation laws, and all the laws we just described in the prior slide. So you still need to make the same inquiries when confronted with an employee that happens to have a medical marijuana card, but also might qualify for protections under other laws. So, for example, we have the Connecticut Commission on Human Rights and Opportunities, the CHRO, is going to take the position, or is taking the position, that employers should accommodate disabled individuals using medical marijuana in Connecticut. Now, there's likely to be an overlap of who qualifies as a disabled person and who qualifies to receive a medical marijuana card, but it might not always be that same one-to-one matchup. So just remember to keep on track and continue to follow the same policies you have in place for those other laws. Similarly, you have the ADA, and that, again, still applies, but also note, and this provision didn't change in the ADA anytime in the past year since PUMA was enacted, but just note that individuals currently engaging in the illegal use of drugs are not protected. But illegal use of drugs doesn't include Schedule I drugs, so that includes marijuana, taken under supervision by a licensed healthcare professional. Now, an argument could be made that someone who qualifies for a medical marijuana card, who, in other words, is under the care of a healthcare professional that has authorized the use of this Schedule I drug. Now, we don't know if that applies, but you have to just be cognizant of this requirement and allowance under the ADA. You're still allowed under the ADA, and have always been, to adopt reasonable policies and procedures to ensure that you're not engaging in the illegal use of drugs. And also recall that PUMA, the anti-discrimination provision in PUMA at least, says that you can't take those prohibited actions solely on the basis of being a qualifying patient, but other illegal use of drugs. So if there's other drugs in play, or potentially qualifying drugs being used during workplace hours, that's something to consider. Again, this is all cumulative laws that you have to consider, PUMA, in addition to the ADA.
So another ADA consideration that we're looking at, and I just want to flag this quickly, because some employers don't realize this, but former or recovering addicts must be accommodated under the ADA. As an employer, you must engage in the interactive process with former or recovering addicts to see if there's a reasonable accommodation to help them perform the essential functions of the job, and that could be a leave of absence or job restructuring in some manner. Usually it's going to be some sort of leave of absence to assist with the recovery. Note, however, that drug addicts may suffer from a disability under the ADA, provided that they are not currently using drugs or marijuana. Another ADA issue to look out for is that you have to accommodate employees with a disability who is a medical marijuana user. Same under state laws we discussed. You have to engage in the interactive process, find out if there's medicine or therapy or some other accommodation that might alleviate symptoms. And if there are, you might be able to require the employee to pursue those alternatives, but these are all case-specific analysis. It's very difficult to speak on a macro level about these types of issues because you have, just like a disability accommodation issue, you have to look at the facts of the case and make a determination whether or not somebody has a qualified disability, whether or not you can provide an accommodation, whether or not it's reasonable or provides an undue hardship or a direct threat to the employee or other employees as well. Turning to the next slide, there are risks with accommodating and non-accommodating employees under the ADA. So accommodating employees, impaired individuals might compromise safety. It could provide for greater exposure, could be unknown exposure for employees who might be dealing in safety-sensitive positions. If they engage in some sort of accident that results in catastrophic injury or death to the person or to others around them. And also there's the risk of dealing with law enforcement activity as well. As we know, the Obama administration had taken a little bit of a relaxed approach to enforcement of federal criminal laws concerning marijuana use that's lawful under state law. The Department of Justice has rescinded that guidance and is purportedly going to be aggressively enforcing marijuana, federal laws at least. So there's some uncertainty there of how the interaction between federal and state law. But then again, there's some risk with not accommodating. And what could that be? Discrimination lawsuits. Could be PUMA lawsuits as well. and also reputational. It could be a hit on a company's reputation in the form of bad press. And we've certainly seen that play out with some of the issues we're dealing with in Connecticut and elsewhere in the state. Not accommodating a person's lawful medical marijuana use could lead to disfavorable or disparaging news articles about the company's employment practices. Turning to FMLA considerations, we have to consider the treatment for substance abuse, including marijuana abuse, may be considered a serious health condition for purposes of FMLA qualifying leave, provided that the conditions for inpatient care and or continuing treatment are met. Treatment for substance abuse does not prevent the employer from taking an adverse employment action against the employee if there are other legitimate reasons. So you just have to make sure that you're cognizant of FMLA concerns when dealing with somebody who might be a qualifying patient or primary caregiver under PUMA. Talked a little bit about OSHA. Again, there is a duty to provide a safe workplace. I think the PUMA accounts for that, and it's not really in conflict with OSHA's requirement to provide a duty to provide a safe workplace because there are the exceptions that do not require an employer to permit the use, consumption, or intoxication of an employee during working hours. Drug-free work policies. Again, PUMA has the carve-out for federal laws that require mandatory drug testing and screening out of applicants who use marijuana. There's nothing, I don't think there's much in the drug-free workplace policies that would be in conflict with PUMA. It's pretty clear under federal law that those DOT-regulated employers still can maintain those Drug-Free Workplace Act requirements. And one last thing we want to talk about is drug testing policy.
Yeah, as you know, I mean, PUMA somewhat added the requirement that you have to take special care when someone confronts you with a marijuana card and says, okay, well, if I have a drug test, it will test positive, and that's because I'm allowed to under state law. But that doesn't mean that you can't still require drug tests. So you're allowed under PUMA to institute a policy that requires employees to disclose the use of medications that may impair their ability to work. And of course, if you do get that likely to be confirmed positive drug test for marijuana, you can very easily comply with PUMA and your drug test policy that you've already instituted by just confirming that the person qualifies under PUMA and then take that action accordingly. That drug testing policy, at least if you're in Connecticut, is governed by Connecticut law. So just be sure that you're aware of, I mean, again, those requirements remained prior to PUMA. So there's separate requirements for the applicants. You have to inform them that you're going to have a drug test. And then there's, of course, different requirements for current employees, such as whether you can provide a random urinalysis test. That's usually okay it's only okay for designated safety-sensitive positions. Otherwise, it would require reasonable suspicion in order to conduct a drug test. So just keep in mind that you're allowed to test for some people, and particularly with qualifying patients. You'll know what the result is going to be. The question is, can you take action on that result? And the answer depends on PUMA and all the other laws that you have in place that were in existence prior to PUMA. You just got to be mindful and make sure that you're following your policy, but also following all these laws.
So that wraps up our slideshow presentation, and at this point, we've allotted some time to take written questions. So let's check out and see if anybody submitted a written question.
So it looks like our first question is a great one, and it's an easy one, and it was, will you get a copy of this presentation? And it's my understanding that this will be emailed out, so you'll have this available at the end. We're still happy to take other questions if they're coming in, but
right now we don't see any.
oh, we have a question.
Looks like another one came in. It only says...
It says we have a question.
We have a question.
How does this apply to HIPAA is the question.
How does PUMA apply to HIPAA? That's an interesting question. I don't know in what context we're discussing. Nothing about PUMA does not preempt any HIPAA requirements or conflict with any HIPAA requirements. So to the extent that you're subject to any HIPAA requirements in your industry or as a particular type of employer, you would still want to comply with those HIPAA requirements.
And I guess the next, another way this could relate to HIPAA is suppose you get a drug test result that was instituted, that you took pursuant to your drug test policy you already have in place. Potentially you're thinking about does disclosure of the status of someone as a qualifying patient violate HIPAA? The answer is you would just be mindful of that in any event. The HIPAA requirements would be the same in any drug test result if it applies. And so you just make sure that you qualify under HIPAA as being regulated by it, but it didn't really change the legal landscape of HIPAA.
I agree.
All right, so I think that's all the questions we've gotten.
Yeah, so we don't want to keep anybody else on the line while we're waiting for questions. We've come to the end of our program. We hope that you found the information helpful today. Again, all of today's participants will be receiving an email with the PowerPoint slides, a link to the webinar, and an attendance certificate. Be on the lookout for those materials. They should be in your email box.
Actually, before we end, we just got a question in, and the question is, do you have to make an accommodation for space for staff to use medical marijuana? Now, recall that PUMA does say, or does not necessarily protect current use of medical marijuana in the workplace. Now, again, these other laws might apply, so you have to be careful that you're conducting an inquiry as to whether use in the workplace would constitute a reasonable accommodation, but otherwise PUMA expressly carves out use of qualifying medical marijuana in the workplace.
As a defense side lawyer, I would try to argue that no, it would not space for consumption of medical marijuana while on the job and in the workplace would not constitute a reasonable accommodation under the CFIPA or the ADA. However, again, we don't have a lot of guidance on this, and we're still trying to figure out how the applicable administrative agencies will interpret the accommodation requirements, how the courts in Connecticut will accommodate reasonable accommodation requirements. I know that there is one decision from the Massachusetts State Supreme Court which said that employers do have a duty to engage in the interactive process, and they do have a duty to provide reasonable accommodations to employees and individuals that qualify as lawful medical marijuana users under the Massachusetts statute. Now, that's a different statute with different requirements, and it's not applicable to Connecticut law, but we are looking at the guidance of other states when making these assessments because there is so little interpretation out there. And Massachusetts is similar, but also dissimilar to PUMA. So you would want to err on the side of caution, but accommodating the use of marijuana in the workplace, we would probably try to take a position that that is not a reasonable accommodation.
So we got another comment that says, and I'm not surprised about this at all, but we've seen fraudulent medical pot cards. One person had 6 cards from six different locations. Now, we spoke earlier about, do you really want to inquire when you're presented with a card, all right, do you have a qualifying medical condition, which is what we listed on the other slide? Well, I think it's reasonable to, and I would imagine that the DCP has a method of confirming that a card is valid or confirming that someone has signed up.
That's right. And that is a good question. We are seeing that with various employers. I think the last clause of your question about the person was caught selling dope, if the person is selling illegal drugs in the workplace or on working time, that would be a reason to terminate. There would be nothing wrong with disciplining a person for doing that, because you wouldn't be terminating them solely for their status as a qualifying patient or primary caregiver under the PUMA. But if you have concerns about whether a medical marijuana card is valid, you can follow up with that and attempt to confirm with the Department of Consumer Protection.
We also got a question, does federal FMLA apply to caregiver leave?
I'm not entirely sure where we're going with that question. There are provisions for caregiver leave under the federal FMLA. Whether or not that would apply to a primary caregiver under PUMA is an unsettled question of law. You probably you have to take that one on a case-by-case basis to assess that particular circumstance.
So we had a question that said, could use in the workplace ever be a reasonable accommodation? And by that, we're talking if someone tests positive at work and an adverse action is taken, wouldn't the adverse action be based on being under the influence at work rather than the person's status? Well, that's interesting because the question of whether someone tests positive from a drug test that was taken at work is different from whether the person was consuming the marijuana while at work.
That's right.
And so at that point, if you get a positive test result, you need to inquire, all right, is the person a qualifying patient, which is something that you need to confirm. But then second, is PUMA even applicable? Because remember, PUMA carved out use of qualifying medical marijuana in the workplace.
Yeah. And also, remember, drug testing for marijuana is much different than testing for alcohol or other types of drugs, because depending on the type of drug test that the employer uses, it's very difficult to test for current intoxication, because for urinalysis test, I mean, a urinalysis test can detect up to 30 days prior, and maybe even more in certain circumstances, depending on a person's physical attributes. Oral fluid testing, while more accurate, still can test for intoxication within the past 24 hours. So while somebody might have been intoxicated the day before or the night before, they might not currently be intoxicated the next day while at work. So that's one issue that the employment bar and employers are really having a hard time with, is how do you test for current impairment with medical marijuana or for unlawful marijuana, because the tests really aren't there to pinpoint impairment at an exact time. So I think at this time we've wrapped up with the question portion of this, because we're coming up on our top time allotment. So again, we've come to the end of our program. Everybody should receive the materials in the email within the coming days. If you don't, you can reach out to us and we'd be happy to get those to you. If you have any additional questions, please feel free to reach out to Sarah or me. We'd be happy to discuss these issues in more detail or any case-specific questions you might have. Thanks for your time.
Thank you.